Jack Delange. Jack has a topic today, searching for the future of surveyors' intellectual property. Jack Delange is the director of the Australian Copyright Trust, which has a role in advising surveyors about their intellectual property rights and in aggregating the small royalty amounts available using the funds collectively for the benefit of industry as a whole. Prior to his role, he was COO and CEO in the SEBA Association, and has also had surveying experience, operational management roles in Queensland Government as a Deputy Director and in private enterprise. Thank you, Jack. I'll hand over to you now.
Okay, thank you, Paul, for that introduction. I guess while I'm talking about the future of surveyors IP, it might be good to have a couple of minutes of going back to where we came from and why we're here and who we are and what we do. So most members will know about the moves to absorb copyright in cadastral plans lodged in various titles registries back to the surveyor, or where we thought it always belonged. And we started this officially in 1996, roughly, when I started talking to a local intellectual property lawyer. We went through lots of years of legals, both here and in New South Wales, and Co-opted Copyright Agency Limited into all of that. And we went through legals until about 2008, and got as far as the High Court, when the High Court, in a unanimous decision, decided that yes, surveyors did own the copyright in survey plans that are lodged in the titles of it. So after all of that, we had more legals for several years with the Copyright Tribunal to try and determine how much that royalty ought to be when government make copies and sell them. And that took a few years. But after that, and we first got that in place in New South Wales through Copyright Agency Limited, and then it's now Copyright Agency, or CAL, is rolling out agreements in other state jurisdictions, that will, I'm not quite sure where it's at in other jurisdictions, but in Queensland we got it in 2018, I think, or maybe a bit earlier, and others are rolling out progressively. So we need to remember that copyright is a federal issue, it's a federal legislation, but surveying is a state issue and state legislation. So it's a bit of a hard thing to handle around the place. So the Australian Copyright Trust was formed by the people who were doing this, and mainly SEBA in Queensland, and formed around about 2000. And its purpose is fairly simple: to be an aggregator of copyright royalties. And what we do is aggregate small amounts into useful ones, in other words. And the way I like to demonstrate it is that instead of each surveyor getting enough money every year to buy a carton of beer once or twice a year, we put all that money together and do something really useful for it, with it. And all of that principle is born out of association environment, which Paul has just been talking about, and I was been involved with as well, of course. But my definition of an association is a group of individuals doing collectively those things that are too expensive, too difficult, or even impossible to do individually. That's a fairly simple definition. And here we are, collectively aggregating small amounts of money and doing bigger things. So it fits into that definition of an association quite neatly. And so the system works. The copyright system is working, at least for now. But what is getting to the subject of the conversation is what happens in the future digital world. And digital technology is taking over and making inroads in lots of areas in surveying practice, in the operation of surveying itself, obviously, out in the field, in the preparation of plans, lodgement of plans, and the subsequent use of survey plans. And digital data is replacing the hard copy survey plan that we're all familiar with. And because data can be extracted, displayed, transmitted, and mucked about with far more flexibly than hard copy plans, then there's got to be some new rules somewhere, and the system is going to change. So ACT has established a major research project to find out how these changes are going to affect us in terms of surveyors' intellectual property. In other words, in a number of areas. Firstly, in the recognition of intellectual property in survey plans, how will we recognize that it's there? Is it going to be there at all? what different materials are they going to be? It's not going to be a piece of paper with lines and numbers on it. So how will we recognize the IP? How will we protect it in the future? How will we commercialize it? And remember, IP and copyright is a commercial right, nothing else. It's just that there are other rights, like moral rights embodied in the Act as well. But essentially, copyright is a commercial right, and then we need to think about the commercialization of surveying IP. And also the general management of how practice might need to change to protect it and do all sorts of things. How we collect the royalties from government copying, and potentially how we collect royalties from private copying. So all of those things will be changed in the new digital environment, or the digital disruption, whatever you want to call it. It'll change. So what we've done is developed a brief for a major research project to look at these things and established a number of scenarios for the researchers to look at. And the first one of those is authorship and artificial intelligence. At the moment, the Copyright Act says that a copyright needs to be original and needs to be the result of a human author. But more and more surveying is being done by machines. And it's only a matter of time before the human being is left out of this process. So what does that do? We're now using artificial intelligence instead of intellectual property being created by human authors. So what does that do to the authorship? And we're talking authorship as opposed to ownership. Right? The two are totally different things. We already know that an author, if he's an employee, is not the owner of the copyright. It belongs to his employer. But if a machine creates copyright, presumably the machine is owned by somebody, or it is employed by somebody, and all those things. Where will that happen? Has the machine actually created some IP? We don't even know whether the machine will create IP if it's not a human author. So that's the first scenario. Second one was the originality and technology. Even with a human involved, there are many new technologies in data collection, data presentation, and data use as well. So the question is, does a plan represented as data points still have the same IP protection as the piece of paper with lines? And because the way copyright is described to survey plans is as a work of art. So is it still going to be a work of art, or what is it going to be? We don't know. So we need to research all that and find out. And we already know that a bunch of digits that can be produced a paper plan is as good as the paper plan. That's in the current situation, but what is it going to be like in the future? The third one is authorship and digital records. In the way the storage and manipulation of survey data these days, it's getting harder and harder, in some cases anyway, to trace who the original author was. And we need to have some legislation and operational measures to address that particular problem. So we need to research what they are. The next one is exceptions in data mining. The Law Reform Commission has several times recommended that survey plans in public registers be fair and permitted as copying as an exception, which means that no royalty would be payable. We need to know whether surveyors need to develop new business models in response to this, if it ever happens. Several attorneys general in the federal government have told us it'll never happen, but things can change. Politics is a funny thing. So we need to have an answer to that if it does get towards that position. Open data initiatives is another future thing of the future. Well, it's here already, really. Governments are increasingly adopting open data, and they say that data produced by government initiatives should be openly available. And most people are interpreting that open as being free as well. We know that the two are not the same thing. It can be open and still be charged for, but most people interpret that as being free. So again, where's that going to end in relation to cadastral survey data? And do surveyors need to adopt a new business process or new processes in collecting and developing their data? And in fact, can surveyors collectively develop their own data mining and searching tools? and have it available in some way, and some way have commercialized it themselves. So that's another avenue of research in this project. The smart contracts and blockchain is another area that needs to be looked at. Blockchain technology is already being tested in Sweden to manage property transfers, and manage property transfers with the same security as a Torrens title system. So if that works and it gets extended to elsewhere, then the Torrens title system might disappear. So we need to know if that is possible and what the role of surveyors is going to be when and if that happens, and what those impacts are going to be. And maybe identify new business opportunities for surveyors to be involved in that rather than be tossed out by it. And the other one that we need to look at is TPMs. You've never heard of TPMs, but they're technical protection measures. And TPMs, or technical protection measures, are locks, technical locks that IP owners use to stop copying or access to their data without permission. So we need to know what in the future those TPMs are going to look like. And they can be as simple as just passwords, of course, and they can be very much more complex. So we need to know how to maybe identify those and apply them to surveying IP in the future. And lastly, but not least, is legislation in general terms. The Copyright Act has been reviewed many times since 1980, whatever it was that it started. And there's been several reviews and lots of research on copyright in the digital age, as it were, particularly by the Law Reform Commission. But very little of their discussion talks about surveying IP. We've had a few talks to the Law Reform Commission, and they just don't understand us very much at all, and they don't even think that we probably should have intellectual property at all. But nevertheless, we do. The High Court says so, and we need to make sure that in the digital age, the legislation is looked after, and we need to make the link between us and those those changes to the Copyright Act, and look for their implications and solutions. So those are the areas that the scenarios that we put in his research brief to try and find out where surveying IP is going to be in the future digital age. Where are we with it at the moment? We've got the brief to put together, as I said, and we've cast about for a research institution to try and get this thing going. And we've looked in several places, but we've received recently a proposal from the University of Southern Queensland, which has probably got the largest surveying faculty in Australia, possibly. It also has law faculties, and it has links with the Queensland University of Technology here in Brisbane, and the law faculty at QUT has a fairly high reputation in intellectual property. I had many discussions with them when we were doing all this years ago. So we think that combination might be able to carry out this research for us. And we currently have some proposed names of researchers, but we're still negotiating a contract, so I'll probably not mention who they are at the moment. But hopefully by the time the Locate21 comes along, we'll have started this project, and we'll be able to make some more announcements actually at the time or whatever. And we anticipate that this is going to be 12 months of work. As you can see, it's a lot of legal stuff. It's not all surveying. There's some surveying process, and when you talk to lawyers and ask them for an opinion about whether this is this or this is that, the first thing they ask is who discovered Queensland, and we go right back to Captain Cook and talk about the development of surveying. So there will be some surveying involved, but ultimately there's a lot of legal debate to be had here, and hopefully we'll be able to use this information from this research to lobby the appropriate people, or advocate, I should say. We don't lobby anymore, do we? We advocate. So that's about it. That's where we are. But I should note that while the university is doing the research is in Queensland, the research contract will be to cover all jurisdictions in Australia. we understand, as I said earlier, that the surveying is state-based legislation. So we want to make sure we've covered all bases, not just Queensland. And the research that we're contracting, and it'll be a sizable contract, is to cover all jurisdictions in Australia. So as a final plug from me, I guess that's a good start to say surveyors in other jurisdictions should be getting on this bandwagon and joining the Copyright Trust and collectively doing these things with everybody on board. Thank you.